Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is, What is the Value of Personal Information? Quantifying the Harm Caused by Data Privacy Breaches. The plaintiffs in data privacy class action lawsuits may demand money damages for the loss of the value of their personal information. But how much money is that personal information really worth? And what exactly did they lose? Today's guest is going to tell us why there are no simple answers to these questions, either from an economic perspective or a legal perspective. My co-host today is Yeater. Would you like to introduce our guest and kick off the discussion?
Thanks, Alicia. I'd be happy to. Joining us today is economist Mike Kheyfets, a partner with Washington, D.C.-based Edgeworth Economics. In addition to providing his expertise in a variety of antitrust litigation matters, Mike helps companies involved in data privacy litigation analyze their potential financial exposure resulting from data breaches. Mike holds a Certified Information Privacy Professional U.S. Private Sector certification from the International Association of Privacy Professionals, and he writes and speaks about data breach issues affecting companies in all kinds of industries. We're happy to let listeners know that the webpage for this episode includes a link to one of Mike's articles for Bloomberg Law, in which he explores the lost value of personal information, damage theories from an economic perspective, and hence the topic for today's program. Welcome to our Curious Amalgam, Mike.
Thanks very much. Thank you for having me.
So we know you've worked on different types of litigation, both privacy-related and not. Tell us a little bit about what's distinctive about the economic analyses in data breach cases from your perspective.
Absolutely. And as you said in your very nice introduction, a lot of my practice is in antitrust class actions. And typically, even though those kinds of cases are very analytically complex, there's kind of a core theory of harm that we think about, that there's some sort of anti-competitive conduct that's alleged. And then as a result of that, prices for the products that are at issue have gone up in one way or another. The contrast with data privacy litigation is there's generally not just one theory. Often you'll see 10 or maybe more theories in terms of how did the data breach actually harm the respective class members. And that can be anything from on the more simple range of, plaintiffs claiming that the data breach caused them to go out and pay out of pocket for data private or some kind of software to protect their identity, or maybe they spent time remediating the fallout from the breach, and so they would like their time to be compensated. On the more complicated range of theories, you sort of see these value of information claims where the claim is that the actual information itself, the data that was part of the breach, has value, and so plaintiffs would like to be compensated for any sort of loss to the value of information. So that's kind of the distinctive feature. It's, instead of thinking just of a single model of, how our price is set, you might be thinking of 10 or more different economic models to try to assess the claims.
Mike, do you typically see those models in the same case, or in your experience, have plaintiffs sort of picked a horse and ran with it?
It's sort of a mix. Generally, you see multiple claims in the same case. It's not always the same set, of course, but you do generally see, many different theories all being part of the same case.
And you referenced the value of information theories as being more complex for an economist. What in your mind makes those more complex?
Yeah, I think sort of the core issue with these value information theories, and for an economist, they're fascinating, but they do become more complex because the data that's usually at issue in one of these breaches is what we as economists would call non-rival. And so what that means is that it's the sort of product or good that multiple people can hold simultaneously and use without it being used up or diminished. And so, in contrast with something like a car, where if Aaron, for some reason, you steal my car, I no longer have possession of my car. And, that's sort of a tangible valuation we can conduct. What would it take for me to replace my car? With data, it becomes much more complicated because if for some reason I decide to steal your name and email address, even though I have that information now, obviously you still hold on to that information as well. And so, if you sort of think about people may use their information to sign up for retailer promotional programs, for example, to get a discount or, to get on a mailing list. If my information is stolen, nothing's really preventing me from continuing to use my email address to sign up for those kinds of things. And so that's sort of where you run into the complicated economic problem. If you're trying to think of damages as, what situation am I in after the breach and where would I be if it wasn't for the breach, the so-called but-for world, you sort of have to think about, well, if I can continue to use my information, what is it that I actually have lost?
Yeah, well, I can certainly think from my perspective as a consumer, if not as an antitrust lawyer or consumer protection, law standpoint. Yes, I may not have lost my personal information. I lost my expectation of privacy. I've irretrievably lost, and I think maybe I'm entitled to get back any money I spent to have that third party maintain the privacy of my information. But I also wouldn't say that my personal information has no value because I know there's a big market for it. So how do when you go to analyze a damages claim in a privacy breach case, which approach are you taking? Are you taking all of them at the same time? How does that work?
Well, I think that's part of the issue. When you have these multiple theories simultaneously, the different issues sort of get bucketed. So, if one reason certainly we think our information has value is because it could serve as an input into fraudulent activity, right? So whether or not our Social Security sort of intrinsically has value, certainly we know that a bad actor with our Social Security information in hand and maybe some other pieces of information about us, they can use that information to open fraudulent accounts, commit some sort of fraud against you. And that's certainly a reality of how that information can be used. But this is where you sort of run into when you have these multiple different theories. One of the other theories that we didn't really mention in the introduction, but restitution for any sort of fraudulent activity is another separate theory. And so, certainly if somebody opened an account in your name and, had some sort of effect on your credit score, for example, that's a separate theory of harm. But this value of information theory is very curious and interesting because, it sort of presumes that the information itself sort of intrinsically has value that we need to recover through the litigation process.
Yeah, Mike, it sounds like in part we've got a bit of a competing theory between the risks that occur when your data is being lost or misused versus the opportunity that you might have to sell your data to somebody yourself as opposed to having it sold for you. Is that sort of a way to summarize the dichotomy?
I think it's a good way to put it. And, to the second point, and Alicia, you mentioned this as well, there being markets for information. I think, Aaron, that's kind of, the second part of your point is, do we actually as individuals have the opportunity to sell our personal data? And that's sort of the fascinating question. For me as an economist working on these cases, often what you see, the claimants would point to kind of two types of markets in trying to make this claim. Well, markets do exist and, we can study those markets to try to figure out value. But the two kinds of markets we see offered are, one kind is so-called black market. And sometimes we hear the term the dark web. That's these websites that are not easily accessible, but, where bad actors go to sell all sorts of illicit stuff, including stolen information. And the way you see these dark web markets offered is, somebody might say, well, look, I can go to the dark web right now and I can buy a Social Security number for $10. And so that tells me that if my social security number was stolen in a breach, that's deprived me of $10 of value. And that sort of sounds sensible. Like it sort of sounds like you have certain pieces to evaluation analysis in place. But again, you have to be thinking about what is the actual world? What is the but for world? Is it actually the case that but for this breach that I was a part of, would I personally as an individual go to the dark web and offer my social security number for sale to the bad guys? And if that's not a realistic scenario, it's not a transaction that anybody could or would engage in, then you sort of have to start questioning, is that really a benchmark that's useful for this set of facts that we're looking at in this particular litigation?
Well, and just to compound that problem, I would think it would be difficult to assume that the risks to me of my data being misused by the dark web are equivalent to the $10 someone on the dark web would pay for that information.
Right, exactly. And that's sort of, again, not to get too much into the semantics of economic jargon, but you should have to start thinking about, what does it mean for something to have value? Who's that value accruing to? Why is it accruing to them, right? So the fact that somebody wants to buy your social security number for $10 because they intend to open fraudulent accounts in your name, again, if you're thinking in the damages context to just a typical individual, does any of that really have relevance to how you would assess that individual situation?
So we've talked a lot about this theory of data having value, or this concept of the data having value, and it seems intuitive to all of us, I think, that this information has value to somebody at least. But you also talked about data being non-rivalrous. And I think that the definition you were using there would suggest that it's possible for many people to own that data, or for much of that data to be, essentially duplicative of somebody else's data in a way that makes it not very interesting. Let's just say it that way. So how do we square these things? Do the data have value, or do they not have value?
I think data certainly has value in certain contexts. And of course, we just talked about the dark web and the black market for data. It certainly has value to certain actors in that particular context. There are legitimate markets for information. A lot of times individuals like us don't have access to those markets, and we can't necessarily go out to a marketplace and say, hey, here's my social security number. What is somebody willing to pay for it? But, there are these companies called data aggregators, data brokers, that part of their business model is they sort of, not in an illicit way, but they sort of collect information from public sources. They scrape websites, and what they do is they take many different sources of information. They collect information across many different people. And they sort of create these curated data sets that can be used for marketing, for example, right? So the simple example, the company wants to target a certain demographic, and they'd like a mailing list of people within that demographic they could sell a product to. And so they might go to a data broker and say, hey, this is a product we're selling. Help us get access to individuals that might want to buy it. So certainly that's a context where you could say data has value. But again, you have to sort of bring that back then to the context that we started with, which is, these data privacy litigations. You or I as individuals, can we go to a company that's trying to sell us something and say, here's my mailing information, please give me something in return? Because a lot of the value that the data broker provides is in the fact that they can give you a list of many people that you can try to solicit, a more complicated set of, demographic characteristics, geographic characteristics. There's a lot more sort of the compilation is the value that they add, and the cleaning. And so again, do markets for data exist? They absolutely do. How do we use that information then to assess a damages theory?
So when a breach takes place, it's fairly common, I think, for a potential class member or plaintiff, depending on the circumstances, the victim, in effect, to receive an offer for identity protection services or some other kind of service for free to mitigate the harms some of the harms at least that you're talking about, Mike. And I'm curious what we can learn from that offer and from the value of those services in your mind about the value of data here.
And I think we've all gotten these notices that come in the mail every so often, and there's an offer to sign up for some sort of identity protection program. You often get 24 free months. Behind the scenes, when there's a triage that happens at a company after it's been the victim of a cyber attack, that process is quite complicated, and a lot goes into sort of figuring out this variety of different state level rules about notification and so on. And so, in determining who gets the offer, in my experience, there's a process that companies go through that's not necessarily always as detailed or granular as to even identify who specifically were the people that were part of the breach, or what even the information was that was exfiltrated. And from a technical perspective, that sometimes it's actually very hard to do. And in many cases, the company might not actually ever know exactly what was stolen or who was subject to the breach. And so when that offer of that identity protection gets put together, it'll oftentimes sweep in people that are likely to not have been part of the breach or maybe definitively weren't. And so that's where we have to be a little bit careful. The offer is sort of a business decision that gets made. And so we should be cautious about inferring, well, I'm being offered a product that on the open market costs $19.99 a month, and that somehow directly relates to how I personally was harmed. Because, again, it's the set of people that get that offer can be very differently situated, up to and including just sort of incidentally getting put on the list, even though they weren't themselves directly affected.
It also would seem that those services go to one of the two theories of harm that you described, meaning that it protects you from the misuse of your data, but it doesn't really give you back the ability to control whether the data is being sold for legitimate purposes.
Exactly. It's, there's a lot of sort of prophylactic ex post processes that are in place. Some of it are mandated by statute. Some of them, the company might have some latitude, but it's really remediation ex post rather than, putting the genie back in the bottle, so to speak.
We've talked about data in kind of a lump today for the most part. And I'm wondering if it would be useful for you to draw some distinctions among kinds of data. So particularly, one extreme you've already referenced, the Social Security number, I think, is one that, has particular value. There are probably some lower value things. No one really cares what my middle name is, I suspect. But I'm curious sort of how we should think about that array of data and what's at the more valuable end, what's at the less valuable end. And is it right that in fact that there are more and less, or is everything useful because nefarious actors are creative?
I think generally, it's fair to think of there being a continuum. I think it's fair to say, most people don't care what any of our middle names are in a vacuum. Certainly a lot of information is available online just publicly, right? There are all sorts of websites. If you just were to Google your name, something might come up that looks kind of intrusive in terms of having your phone number, your address up there. So there's a lot of sort of public record scraping that happens that we really as individuals can't control. And I do think, we still try to protect our Social Security numbers. We try to protect bank account numbers. So, I think it is fair to say there's a continuum. I do think, it's still the case that all data is non-rival. And so in the same way that you don't stop being able to use your name and email after it's been in a breach, you don't stop being able to use your, credit card number or Social Security number. So that is sort of a common thread across different types of data. But, it's certainly true. Like you said, if you think of data more as an input into some other illicit activity rather than something that just holds value in and of itself, it's certainly the case, right? You need it's not sufficient to have someone's email address to open a credit card account or to open, a fraudulent account. So yeah, certainly to actors that are looking to misuse our data, there's certainly differences in value.
Now, Mike, you've been presumably doing this sort of work in the context of litigation or potential litigation, at least. What can you tell us about how the courts are handling these issues?
It's interesting because these cases are still pretty recent. And as I sort of try to think, I don't know that I've actually seen one that's gone all the way to a verdict, where we actually see how would a jury actually grapple with these issues. But certainly at an earlier stage in the litigation, even at the motion to dismiss, you kind of see it go both ways. I've seen courts dismiss data breach cases, saying just there has been even sufficient argument put forward that that's sort of a plausible theory. I've seen courts go the other way and say, you can sort of assess it fully at trial, but it's sufficient to pass motion to dismiss. So it's interesting to see, where these go. These cases are evolving very quickly, even from, when I started working on these matters some years ago. The thinking has evolved, the arguments have evolved, the economic analysis is catching up, and people are becoming more sophisticated. But yeah, I think we're yet to see exactly where we end up.
Okay, well, we'll certainly keep an eye on this, and I expect maybe we'll do another episode in a year or 2 or 3 when perhaps some more case law has been rolled out. Thank you, Mike and Aaron, for a very interesting discussion. I think we've given listeners lots of food for thought. Before we let Mike go, though, we will ask him the question we ask all of our guests on our Curious Amalgam, because we're curious. Tell us something interesting about yourself that is outside of your professional life.
Well, I think, Aaron, I'm sure you know this, and Alicia, I'm sure you do as well, but expert work is very high stakes and high intensity. And so what I decided to do to blow off a little steam on the weekends is to assistant coach my 6-year-old son's soccer team. And it's a lot of fun, and it's great to see the kids learning skills and having fun, and good way to be outside. But I was definitely wrong about that being a low intensity hobby.
Yeah, aren't parents getting in your face? I heard that's a terribly stressful volunteer job.
Yeah, I haven't had problems with parents yet, but it's the kids themselves are so intense about it. We're not even supposed to keep score at this age, but I think every kid keeps their own score. And then after the game, everybody tries to sort out which score is the right one. So yeah, it's high stakes stuff.
Your league, I think, is more intense than my son's league, which was mostly 6-year-olds just running around in circles, as far as I could tell. But
wow, well, they're only going to get more intense as they get older. Maybe you can be a good role model for just chilling out a little.
We'll bring it back down if we can.
Yeah. Well, thanks for sharing that. We're going to ask you to share something else, an answer to a surprise question that we're going to pull out of our virtual Curious Hat.
And now it's time for the Curious Hat.
Okay, I've asked Aaron to select a question at random to ask Mike. Go ahead, Aaron.
Mike, are you a cat person, a dog person, neither, and why?
So I think that for a long time I was neither, but a few months ago we actually adopted a puppy, and so I'm strongly now in the dog person camp. I resisted for a while, and my family prevailed, and now we have an adorable Dachshund Lab mix, and I'm fully on board.
And what's the dog's name?
Her name's Otto.
Oh, okay. Well, give Otto a pat. You did a great job. Thanks to Mike, Aaron, and everybody listening, and join us next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.